This is interesting too, because they say to move it against them, so you know.
Okay,
$3,000.
call the order.
I read that across the building of fires.
Right, but there's.
Anybody not present?
Oh, I didn't think that would be possible. Oh, I see what you're saying.
Define presence.
There's some.
Reasonably present,
Well,
yeah.
Define a reason.
In the moment. Is everyone in the moment?
yeah, I don't know the answers.
Okay. Chris McGrath,
Yeah,
you're present.
yeah.
Andrea, Brian,
Here.
I just asked them.
I'm present. Ruth Heinz.
Yes, sir.
David Van Houten.
Yes, sir.
Okay. Staff present, Mary
Game's all here.
and Liz. Okay, is Liz just the one who's present? Yeah, okay.
Mary's not here.
Yes.
I'm around.
I
All right.
can't see right here, so it's not here.
We have minutes from last week. You gotten a chance to take a look at them, or should we take a minute?
Yeah, let's take it. Did we get these in the email?
No,
No, yeah, then I need to read them.
okay. So we'll take a couple of minutes to look over the meeting minutes, and then we'll vote on them.
Okay.
Need a motion?
You said, Ruth?
We're just still reading.
Okay.
No, there's still story. I apologize.
Okay. We have a motion to accept.
I'm still reading.
Okay,
I thought everyone was done, that's why I said it.
So there's just, on the bottom page one, the flare was originally located too close to the building. Needs another O for too close.
What line?
Oh, sorry, 35.
Oh,
Page 4, line 113, I would substitute a comma for the David, or for the, period before David's motion to table died.
and I'd like to express my appreciation that my name is spelled correctly the whole way through.
I made it this time.
All right, anything else?
No.
I'm good.
I think I'm good too.
Okay. Motion to accept the minutes?
I mean, motion to the minute.
Second,
Okay,
second it.
any discussion? Okay,
As amended.
As amended.
as amended. All in favor, say aye.
Aye.
Okay. So our only business that we know of is continued consideration of the application from North Country Environmental Services and Rudarpa North Country LLC. I think we need to go into a public hearing to hear from Liz and Robert.
So to open it up, so we received yesterday, a letter from Megan Carrier. I believe that was. Yes, Megan Carrier, and I believe that's their council, their legal counsel. They wrote a letter for evidence as the good faith error. And so it's up to the board to review it and make that decision.
So we have the letter and also the permit and the certificate of completion. Anybody wants to look at those?
Yes, that is the original building permit from 2021, and then the certificate of occupancy that was granted or approved in 2025
After the flare was removed.
after the flare was relocated.
So do we have the plans too or not?
I gave you guys the plans at the last meeting. I don't know if you guys brought your.
Sorry, I should have it.
Yeah.
I should have, oh, that's.
Do you mean the plan, the original plan that
The-
they presented to the planning board, or
Well,
what they
since-
gave us the other night?
This certifies that the building.
Yeah, this is the original plan here with the flare next to the building.
Okay, but that is from when? That's from.
This is from 2021.
Okay, so but this talks about 2025 when they moved the
Yes.
flare, right?
Yes.
So do we have the plans for that?
Yes, that was also included.
Okay.
The last.
Yeah, I don't have that in this, but we had the maps before.
So there were extra copies of those for everybody or
No,
do we have those?
did not make a copies of those.
Do we have, I mean,
I'm
pictures.
Gonna try to pull it. Did you have it from last week?
Yeah, well, from last meeting. Yeah.
Cause I'm just trying to
She
figure
had
out.
put them
So-
all out here.
And. So I'm just curious, like on that map, would. The flare, the location of the flare have been, I mean, the required
Yeah.
setback?
So there are three maps, 2021, this is the flare next to the building.
Yep,
2025, there was the flare next to the setback.
okay,
That was the relocation. And then 2026, the survey for
okay,
the purpose of, I guess, title insurance And that's the one that showed the encroachment.
Okay.
Here's some, maybe
yeah.
those maps is what.
Oh,
Yeah, so this
Those are
has
the ones that came with
some of them.
application.
Okay,
So that's this, for example,
that's the
it's-
one
it's
2025.
25.
Yeah,
And, this is the
the actual.
2026.
Okay.
As built, yeah.
So the certificate of completion is wrong in that it wasn't in compliance.
Well, the town said it was, but.
So when the building inspector usually goes out, they are looking for building code. They don't verify necessarily setbacks. For a CO.
In substantial conformance with the plans. Well, it says.
Yeah. So
So you need.
that the implication is that the relocation or the location of the flare at the time of this is insubstantial.
Ruth,
Yeah,
can you see that letter real quick?
the completion?
Yeah. There.
So here's the 2024 plan. This is showing the. Of the flare, the relocation of it.
Yeah, actually have.
Down here is the
Got,
September 9th,
Yeah.
2024. And this was,
forgot to have a small
Survey.
version of this.
that was done January of 2026. And that shows the encroachment was in here
Yeah.
and the corner of the propane. Which the applicant said that it's easy enough to move the propane tank over. So that could be avoided out the setback.
Thank
Okay,
you, thank you.
one further question. Was there any response from the planning board as far as any other needed permitting?
I did not have a chance to speak with them with the
Okay.
last couple of weeks, it's been a little crazy.
Okay,
But I will see them tomorrow night and I can ask them.
well, that's a question, I guess, then we will consider whether that's a gap in our knowledge or whether we can proceed.
So there was notification in the original packet that I gave you guys, there was some backup documentation of emails that the planning email had received. One in 2023, and that was coming from DES, letting the town know that there is going to be an amendment to their application, their approved application through DES. And that amendment was the relocation of the flare, and that started in 2023. Also in 2023, the fire chief at the time does give a heads up of the property having 2 flares, while the new flare was being serviced and put into commission.
Mhm.
The other one would still be on and off while they were decommissioning tests.
The flare on Rudarpa property or NCS property?
Rudarpa, so the original flare on Rudarpa property was west of the building.
Mhm.
And it was too close to the filling station. The applicant stated that it was too close, so the original flare was like right about here, I think look on the screen,
That's that.
to the west of the building. And this is the gas filling station.
You can click on, you see all the pictures they show in the video, they show in the picture of the plan too. Pull down.
Yep. Let me.
No, she's screen sharing now.
So the original flare was somewhere in this area. And it was too close to the gas filling station, the applicant states. And this is the gas filling station, so they moved it. And. See the one that goes above, right? So here's the corner of the building. And it was going to be moved further away from the filling station.
Mhm.
And that location, it was relocated and then it was within the setback.
So the email then is at least an informal notification of changes to the gas plant property, and there was no response from the planning board.
None that I can find.
Okay. Good.
But didn't we continue the meeting because we wanted to know that? If they had gone to the planning board?
So I hadn't had a chance to actually get the emails. I have the emails now. If you guys want them, I can absolutely pass them along. Just put them in the folder to date.
Well, we're here to discuss if we think the move was a mistake or purposely, or, you know, that's what we're here to discuss. We're not here to discuss the flare itself.
And good.
And as if I put myself in the feet of an applicant. And I might have seen a letter from the town. Saying that, and I quote, the survey project was located above reference locations complete, the project was inspected in a substantial conforms with the plan to provide a kind of Wenham. Time building permit. And applicable to all local state codes, I would take that as I did everything right. So I think we kind of put a shot ourselves in the foot here. Because we have a letter from the town saying that we approved everything. Our plans are complete, we received documentation from DES in 2023, letting us know this was happening. And nothing happened then,
Well, I'd call it due diligence because we didn't know about the existence of that letter before.
well, the town received it.
Well,
we weren't on the board then either.
Yeah, we didn't know
The
about
planning
it.
board must have known about it.
Yeah, so now we know about
Right?
it. I don't know.
Well, plan board
Yeah.
secretary, I'd assume, full of planning board, so I feel we're kind of here, kind of in a sticky situation. The community wants a solution. Our hands are kind of tied, and here we are. Looking back, that we had plenty of opportunity to comment in 2023, and we didn't. Then 2025, we signed up off that everything was okey dokey.
Yeah,
I think we're trying to
so we,
finish this.
if looking at the criteria, we can consider that is that substantial evidence that good faith was maintained. So
I guess I'm having trouble how the 2023 is relevant if they moved it in 2025.
In 2023, I heard Liz correctly,
they got the notice.
DES informed the town that it was being moved.
Yes, in 2023 is when we received the first email from DES. Saying that there was a significant change, a significant amendment to the permit. Their permit for the land gas utility flare. And in reading those documents, it tells you that it is relocation of the flare.
The town was notified.
Right.
That was my question last week meeting.
Yeah.
And that's my answer.
I was notified,
No one did anything about it.
huh?
No one did anything about it.
Mhm.
What's happening here?
I don't know who's talking.
Name and address, please, for the record.
I don't think we allow.
The noise comes from that box.
Yeah, they should be quiet. So as everybody looked at the evidence that we've been presented now and have any further comment or question on it?
Yeah, should they have gotten the building permit when they moved it?
So we don't fully know the answer to that. We have the certificate of occupancy. We don't know, or we're speculating that that addresses whether there would have been a need for an additional building permit. Now.
But didn't
Yeah.
this,
That's what
Yeah.
this letter addresses,
Yeah,
yeah,
or their opinion on it.
yeah,
Well, I mean, yes, this could be solved with their proposed condition of approval.
yes, it could be. So we can include that condition with our approval.
Right.
Okay.
How far is it within the setback? I mean, how it's still barely in, right?
10 feet.
It's 8 feet. Okay.
It's not the road setback, it's the property line setback.
Yeah,
Right, no, I
they
understand
put the south side of the pad instead of the north side of the pad on the setback.
Yeah, so what it looks like is that this was the original location, so this long line here is the setback line. And it looks roughly to be in the same location, except possibly just built backwards. And within the setback, rather than building towards the facility, it was built outwards.
I mean, that drawing makes it look like it's like
Yeah.
4 feet, not 8 feet. Sorry.
So I went and I visited the facility. And this right here is the pad. This is the base of the flare. So the setback line is essentially on the inside of it.
Right, so I think that's
So
it.
it's about 4 feet.
They just put the form on their own side.
Mhm.
Right, we'll hold it down. We'll be close. Okay, okay.
So 4 feet over the 30, I mean, within the 30.
Within it, yep.
Yeah.
So I thought one of our questions also was trying to find out who screwed up. So we still don't know that.
So we can ask Andrew if there's any further information on
Report that stuff.
detective work in terms of where the error might have occurred.
Thank you, guys. Yes, it seems to be that it was an error on the contractor, not on the surveying aspect of it. And like you said, it was a mirror of the pad on the opposite side of the setback line.
Okay. Any other questions?
So, shoot. The estimate, so, I mean, you talk about how, I mean, the goal is to have this operating 24/7, but it's not operating anywhere near that yet, correct?
It's hard to say that it can operate 24/7. It has for extended periods of time. And then there's been days where it has gone down. So if you see it flaring, then the plant itself is not operating.
Okay, so, and what does that depend on? I mean, like, how is it determined when it's gonna operate and when it isn't, and?
It's just a matter of it could be many different items. Could be power outage. It could be landfill gas quality coming into the facility itself could be off, or it could be in the most recent case an equipment issue that we had mentioned last time. We had a server that was down and could not operate the facility from that. So the bypass is to the flare, and that is how it is permitted through DES.
And I would remind everyone that we just have to focus on the 4 criteria. So we just have to be able to tie whatever we're asking back to one of the criteria.
Right, no, I'm just kind of curious because, I mean, the estimate of the amount of loss to Rudarpa, I'm just kind of curious to understand that. Is that based on operating 24/7, that $1 million figure or whatever it was?
To move it.
1.1 million.
No, yeah, so there's the cost of actually physically moving it, and then there was the largest part of the cost was the amount of downtime. So I'm just trying to figure out if the downtime is based on operating constantly or on its actual operation. Because if it's only operating 70% and you're basing it on 100% operation, then I kind of want to know that.
Okay. General question on that. Outside of the 1.1 million or figure that was there, the other figure for relocation, if you just considered that, wouldn't that be in itself a high cost for requiring or for at least leaning towards checking the box for that criteria? I mean, $100,000 for moving it is still high.
Well, I have a question about that though, because the letter we got from the attorney, the Sheehan Finney, it says something about permits aren't required unless it's over $3,000. But if it's going to cost $100,000 to move, then you would think they should have had a permit.
Without here.
Yeah, I mean,
That's the money.
it raises two questions. One is the stack a structure? And was a building permit required for that specific relocation?
Right.
And the letter also proposes a condition that, you know, a building permit be obtained if necessary, that work be done to remedy that failing.
Right.
So,
That's something we can't decide. It's out of our hands, but.
right, but we can add the condition
Right.
that be decided. So,
But that's what we wanted to have
yeah,
answered.
so, well, we can't answer that, have that answered now, but we can put it as a condition. I mean, we could continue and say, okay, let's go talk to the planning board and so on, but, well, my view is that is not necessary this time, that we can proceed,
Okay.
but, everyone's free to object to that. I'll make a motion to continue.
Second.
No, I'm
If
not.
We have to request another.
Yeah.
Oh, wait.
Yeah, I didn't. I said someone could.
Oh, I think that's you with the narrow.
Sorry about that. Okay. Any other questions for Liz or Andrew?
You're gonna open it public?
Yes, I thought I'd do that afterwards. Okay.
Okay, so I still want to get back to, so the cost of this, so if the contractor messed up, wouldn't the contractor be liable for your expense in moving it? I mean, ultimately,
No, not the way this contract was structured, I believe.
that's all. Okay. So if the,
Don't ask him anything hard. He's driving.
I know, I know, there's that, yeah.
I'm a passenger. Apologies. I'm in
Okay.
North Carolina at another project site.
That 4 feet off too.
Okay. Any further questions for Andrew, or should we ask for any further public comment?
I'm good.
Okay, any further public comment?
Mary Moritz. I believe at the last hearing, Andrew explained that the prior Rudarpa had put in the flare. It wasn't this company that put in the flare. Is that correct?
Yeah, that's what
Is that,
They
Public-
moved it.
they moved. Public.
so the prior company installed the first one that was put in the wrong location. It was too close to the gas tanks to make it. So therefore, that's why it was moved. It wasn't moved arbitrarily for a more convenient location. It was moved for safety concern.
Right.
And so my next question to that is, regardless whether a building permit would have been required or not, that wasn't completed, they are willing to do a building permit. And so not certainly not having formed my own opinion, but given the fact that they moved, this new company moved it at a expensive cost for safety reasons.
Well, so I think that's not entirely correct. I think
Okay,
the previous, so Rudarpa moved the flare. They're now owned by Verity.
No, Verity moved it.
Or Verity moved it and they're now owned by Rudarpa. So it was the previous, what? Wait,
No,
Ma-
the current company moved the. Mary's correct.
Okay,
Andrew, could you clarify that?
Yes. And so technically the same company, Rudarpa North Country LLC, it's been the same company from the beginning. The ownership behind Rudarpa North Country LLC has changed. So that originally was Rudarpa Inc. And a few different investors, and Verity purchased that entity. So we own the entity, we are the new owners, but the entity itself who permitted the flare and then moved the flare, the legal entity had not changed.
Right, but the ultimate owner changed after the relocation, correct?
Prior, no, prior.
Prior, okay.
Yeah.
Oh, then I did have it wrong. Sorry. Thank you for that.
No, you had it right. I had it wrong.
Can I add something about building permits? It's my experience in building permits from talking to Bob in the past that when you apply for a building permit and you give your setbacks, the town doesn't go necessarily measure those because the town is not surveyors.
Correct.
So, I'm not trying, I just devil's advocate here. But if they file a permit, if they had, and the building permit went up to inspect it, then we might still not have known it's 4 feet off because there's no like set thing. Like the road was right there, it'd be one thing, but the property line is the property line, and the town's not liable for checking those things.
That,
Do you remember that?
We are not licensed land surveyors,
Right.
so we cannot be.
So I'm not saying we should or should not, but building permit would not have stopped with regards to that.
Thank you, because that is typically when a property comes in for the building inspection, we do measure it using our GIS tool.
Right.
And that is how we gauge our setbacks.
That's not.
It's not 100% either. It's as accurate.
Yeah.
So I
Right.
just wanted, so thank you
So
very
it
much.
would not have been required for the certificate of completion to do an as-built survey.
Not of, the town certainly wouldn't have provided that as a service. And
No,
we
not
don't
just-
require it
yeah,
as
exactly.
as part of the final occupancy, so.
There are places where, as part of the building permit, they would require a post-construction survey, but not here. And so this was
Correct.
done according to that book.
Yeah.
Okay,
So thank you.
thanks. Anyone else?
Should we offer them and say they can read the spring letter?
Sure.
If anybody's curious about the letter that we got from,
It's part of the public records.
so it's part of the record, anybody wants to read it?
Hey, Bobby.
I'm just taking my time to read them.
Bob Murray, Swayze Lane. It's nice to meet all of you tonight, except I haven't met you yet.
Stay there.
He doesn't live on Sway.
I met you now. About 40 years ago, I was here in this room. I was trying to get my house built, small ranch, about 33 feet by 28. And I had a judge stand up and he said, my wife and I like walking down Swayze Lane. They didn't want me to put the power line across the road to my house. They wanted me to bury it. So anyway, building 1990, finished in 2006. That was my legal remedy. Their legal remedy is a lot line adjustment. All this paper going back and forth. They're looking for an equitable remedy that I don't think they're entitled to. Licensee, licensor, owner, operator. Good luck. Why burden yourselves with this? He even stated, I think that's the same person, that the reason why he's coming to you is because he doesn't have enough time. Well, I had enough time. He should have enough time to do a lot adjustment. And that's where I think it stands. I wouldn't vote any other way if I was sitting on board. Thank you very much.
Thank you for your input. Anyone else?
Good evening, everybody. Rich Southwell, 238 Whitefield Road. I agree with Bob, and I think I was circling around the same place the last time around, which is this is not proper remedy for this. They could just move the lots, and it's definitely not a cost issue because I've done enough lot line adjustments in this town. It's a couple $100 in survey work and a trip to the planning board. And so given it seems like we got a little more clarity about what happened, looks like an accident, but it just, unfortunately, they're tarred with the brush of everything else that goes on down at that site, which is, there have been operational failures and mistakes for a very long time. And so when somebody comes looking for kind of maybe not the best, easiest remedy, and they don't have the firmest story about what happened and how it happened, suspicions arise. And there's another remedy here. And like this equitable relief, and to Bob's point, the amount of paper and the number of trees that were slaughtered in the preparation for this meeting, it raises suspicion, and I still don't have a clear understanding as to why we're here for a second meeting when 30 days you can have a lot line adjustment done for cheap. So thank you.
Thanks, Rich. Anything else in terms of input or questions? Or shall we close the public hearing?
Okay, by me.
All right, move to close.
Second.
All in favor?
I-
Aye. Okay. So last time we went through the first criterion and approved it. And then discussed but did not move or vote on the next, what are the 4 criteria. So I propose that we look at criterion 2. So
It looks to me like it was a good faith error in measurement.
mhm. That's my opinion as well. Any other discussion? We move to approve criterion 2 then.
So moved.
Second.
All in favor?
I-
Okay. Let's go to criterion 3. Explain how the nonconformity does not constitute a nuisance nor diminish the value or interfere with future uses of other property in the area. The abutting parcel is owned by the same owner as the parcel in violation. This is located adjacent to landfill property.
This one I struggled with because we heard a lot of complaints last meeting. Also, pictures of that flare being seen for miles. But that's not why we're here. With 4 feet,
Yeah.
moving that change to what the people see. The answer to that, I believe, is no.
I agree.
Much as I hate to say it.
Yeah.
Yeah, the violation is not the public nuisance.
No, exactly. All right. We move to accept criterion 3.
So moved.
Second.
I'll
Are you
second.
calling for, or, okay.
Yes. All in favor? Aye.
I.
Okay. Criterion 3 is accepted. Let's move to criterion 4. Explain how the cost of correction far outweighs any public benefit to be gained.
That's
So-
what I said at criteria 3 is not going to, no matter, once you move it miles, not gonna change what we're seeing.
Yeah, so
So it's kind of a cost benefits analysis, and
mhm.
I mean, I don't think there's anything to be gained by moving it, quite honestly.
Not 4 feet. No.
No.
Yeah. So, you know, as we've noted from various inputs, there are 2, alternatives to the waiver. One is moving the whole thing 4 feet, building a new pad, and however much downtime that involves. And the other is doing a lot line adjustment, and that's X amount of money, but it is some amount of money. And is there any public benefit to be gained from doing that instead that has any value?
Doing a lot line adjustment, you mean?
Yeah.
I mean, zoning and Liz, I guess this question's for you. Any decision the zoning makes is a one-time decision. It doesn't set a precedent.
Correct.
to others
Yes,
to
case by
say.
case basis.
Yeah.
I thought, I just wanted to have it on
Yes.
record and clarify.
Yes. And that does not excuse this same property from not following the ordinance for
Mhm.
anything else. All the
Yeah.
rules and regulations still must comply with.
Now, we've been talking about the flare. Do we feel the same about the tank?
Oh, did you guys agree to move the tank?
User-
Actually,
Full of regulations right now, at
Yeah.
the last meeting, no, yes.
yeah, we're gonna look
they
at
did
this.
State that they can just move that, setback.
Oh, okay.
Yeah,
You could always put that as a condition.
yeah, as far as my understanding, the application only pertained to the flare. So,
Oh,
Attached to you.
Mhm.
Here it is, sorry. Okay.
yeah,
Well, it says two structures encroaching into the 30-foot side setback.
yeah, so the response for criterion 4 is the propane tank may be moved with limited costs, however, relocating the flare would cost a bit more. So, we can, of course, second guess Rudarpa about the lot line adjustment, but this is what they've applied for, and so we need to rule on this, I think, specifically.
well, can we get out of public, get out so we can ask Andrew for sure whether they're moving the tank or not?
Or we can just put it as a condition.
Oh, okay.
Makes sense.
Or I mean, they're conceding that it's not a large cost to move it, right? So.
Yeah,
So then it fails on the cost benefit analysis.
okay.
You know, the benefit may be zero. I don't know.
So why don't we consider whether we accept criterion 4 and then decide what conditions we want to put on the overall approval? Does that make sense?
Sounds fair.
Okay. Anybody want to move to accept criterion 4?
So moved.
Second?
I'll second.
Okay, all in favor?
Aye.
Okay. So I think we've discussed 2 conditions so far. One is that the propane tank be moved. So the propane tank moved so that it's in compliance with the setback. And the second, figure out how to word this, along the lines of the proposed condition that the applicant consult the planning board whether a building or other permit was required, and then seek to redress those permits if they were necessary.
So the planning board and the town, so the
Yes.
building permit would go through the town and the planning board for a site plan,
Yes,
okay.
Can we do that?
You can require, yeah, you can require as bills to be submitted to the planning board review them,
Mhm.
and as well as the building permit.
So there's 3 conditions then. We have 3 conditions.
Yeah.
We have condition for the planning board, the building permit, and the propane tank.
And is there a timeline
30 days.
for those
You
conditions?
guys can absolutely set one.
30 days.
These 30 days are reasonable for the approval? Given the fact that-
well, it's reasonable for the consultation, not for the permitting process, I would think.
To get it, for the building permit, yes, we can get that. The planning board, we're going to meet tomorrow. And then the 24th.
This is right here within time frames we established. So I say we establish 30 days.
60, what's all the 60 days?
Okay.
60 sounds
Yeah,
good.
that's what I am.
Okay.
Yes,
I don't want
sounds good.
to procrastinate, that's all.
30 days would leave me 1 day of breathing room.
So you're that good.
60 days.
All right, 60 days.
So I don't think that we can put this condition on, but there are questions, I think, that pertain to the zoning board about adherence to the conditions on which the special exception that this good faith was based on occurred. But it's not to us to consider the enforcement of those conditions, so think we can note that in the minutes, but I don't know that we can put a condition on the approval to that effect.
Yeah, that would be a separate.
Yeah,
Go to the select board.
yeah. Well, so I think I'd like to note that in the minutes, but set that aside in terms of the approval. So anything other discussion, or should we go to the overall approval of the waiver?
The letter.
Move? I move we approve the waiver,
Subject to the conditions.
subject to the conditions laid out.
So,
All in favor?
Right.
Aye. Okay,
So I will type up the notice of decision, and then I will send it over to you for signature. And then, we will get it to Andrew within 5 days.
all right. Any other business?
Well, actually, I have a question for Andrew, which is
So-
relevant to comments that we got at the last hearing.
Okay,
Time for that question?
well, it's a good question.
You're done with deliberations and you've made your final decision. The application has been approved. Regularly. Potentially, yes.
So I know you heard as well as we all did last time about the unsightliness of the flare, light leaking off and so forth. And I just wondered, isn't there a way that you could put a baffle around that so it wasn't that they having such an effect on the night sky?
I do not know. I will look into that.
Okay. You've had a lot of friends, I bet. You won't hear it.
Totally informally.
Got it. Appreciate that. Thank you.
Okay, if there's no further business, I move that we adjourn the meeting.
I second it.
All in favor?
Aye.
Aye. Thank you very much. Thank you, Andrew. Appreciate it.
Thank you.
Thank you, Go. Thank you
Bob
for your
and
time.
Rich and Mary.